The case management context is a context in which, for the purpose of a trial, the judge asks the parties how they're going to proceed. That's what I understand case management. Your lordships have had many occasions to point out the significance of the case management process. And my respectful submission is that it is in that case management process where, one, the party gives an indication to the court that I intend to call these witnesses. Now, if the party gives that indication, then respectfully, the party has made an election to adduce evidence. And my lords, that is the basis on which the court made orders at the stage of case management as to when witness statements should be put in. The court made orders on the basis of the election that they had. So,
no, Mr. Giza's point of correction. The orders for witness statements is made at the application for direction stage and not at the case management.
The orders
is made on the order 32. Yes, the application for direction stage.
But my lord, that is the situation here is different from the pure high court situation, because in this case, at the case management stage, in this situation, we did not have a direct application for directions, my lord. We did not have that. I believe that's common ground between us. So in this case, we move to the case management stage. And in the case management stage, the court makes orders on the basis of representations that are made to the court by the parties. And respectfully, the representation that was made to the court at that stage is that we are going to call a witness, and we will provide a witness statement on behalf of that witness. That's the clear indication that they gave. Otherwise, the court would not have made an order, submit your witness statement by such and such a date. That is very clear, my lord.
I wish to come in, Mr. Chikata. Now, are you saying that if you decide to call 5 or 6 witnesses and you put in 5 or 6 witness statements, you cannot at any point in time tell the court that though you have put in 6 witness statements, you are not going to call all the 6? Can't you say that?
My lords, you can say that.
Yes, please.
My lords, you can say that, but that is not what is dealt with in Order 36.3, which is what they're coming on.
You see, under the normal civil procedure, if the prosecution closes its case, and that may be the plaintiffs, that's what I'm using prosecution in the civil sense, for the plaintiffs.
My lords, with the greatest respect, yes, let's just stick to what we're familiar with. If you say prosecution in the civil...
Okay, so if the plaintiff closes his case, and the defendant realizes that the case the plaintiff has made has no substance, or does not establish the reliefs he is claiming, and there will be no need for him to testify, you know, he can tell the court that he will not testify, and then he will be put to his election. Whether, if the court rules in respect of his application, he will still testify or he will not testify.
My lord,
that is the procedure.
My lord, with the greatest respect, that is not the procedure under our rules. With the greatest respect, that procedure may apply under the English civil procedure rules, but it does not apply under our rules. And with the greatest respect, if I'm wrong in that, I would stand to be corrected. Which rule under our rules has that provision?
It's a settled practice.
My lord,
we adopt. So are you saying that
my lord,
a party cannot say that I will not testify, judge the case according to the evidence you have?
My lords,
because you cannot compare anybody to testify.
My lords, with the greatest respect, my lords, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. If your lordship is referring to a submission of no case at the end of testimony. If that's what your lordship is adverting to, my respectful submission is that, one, under English common law, it is in fact not available in a trial which is not before the jury. Under common law, the authorities are clear that that process that your lordship just described is not available. And I am prepared to cite some authorities in the common law which make that clear, including a well-known case of Alexander and Racine. But, my lord, before coming to that, I just wish to clarify that the common law position is very clear. Where there is a jury, it is open under the common law. Where there's a jury, it is open for where there's a jury, it is open for the plaintiff to say indeed that I don't want the matter to go before the jury. I'm ending at the point of the trial judge. But the common law position that has been clearly stated in the English Court of Appeal is that where there is only a judge and not a jury, that procedure is unacceptable. And there's a very clear reason given for it in the authorities, which I'll come to. But, my lord, I want to...
Mr. Chief, I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My lord, that is not what I'm suggesting. I'm just suggesting that Order 36, Rule 3, applies in terms of the precondition that is put there. In terms of the precondition, it says where the defendant elects not to adduce evidence, then whether or not the defendant, and I'm saying respectfully that in this case, the first respondent elected to give evidence and notify the court as such. The first defendant elected to give evidence, notify the court as such, and on that basis, the court made an order for a witness statement to be provided.
Mr. Chikata, you are aware that at case management stage, nobody knows the evidence that the others bring. It is after case management orders that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity, because that is a chronological necessity. A case management happens before witnesses are called to testify, so there can't be any doubts about that. I'm referring to the fact that under Order 36.3, which counsel for the first defendant is seeking to come under. And, my lord, this is also different from the submission of no case under the common law.
Excuse me. Order 36 for sub-rules 2 and 3 together. It says, subject to sub-rules, the plaintiff shall begin by opening the plaintiff's case. Then 2, where the defendant elects not to adduce, 3, where the defendant elects not to adduce evidence. It presupposes that the plaintiff has finished his case. That is my understanding. I stand to correct it.
My lord, respectfully, that cannot. Respectfully, that cannot be the case. Because, my lord, Order 36.4.3, and respectfully, as I said, those rules predated CI 87 on case management. CI 87 introduces case management on the basis of which your lordships have proceeded and given orders. And respectfully, I'm submitting that under the terms of CI 47, Order 36, Rule 3, where the defendant elects not to adduce evidence is a precondition for that. And in this case, the defendant at the case management stage represented that they would adduce evidence, and therefore that precondition does not exist. And the defendant made those representations to the court and to the court in a manner which led your lordships to determine.
Mr. Chikata, may I seek clarification?
Yes, my lord.
Are you suggesting that under the case management regime, a defendant who indicates to the court before evidence is taken that I will call one or two witnesses in this matter, then after the plaintiff has given evidence, the defendant says, I don't think I need to call any evidence. Determine the matter on the basis of what the plaintiff has brought. Cannot do so?
Yes, my lord, I'm saying that he cannot do so where the court, on the basis of their representation, has ordered witness statements to be submitted. Because where he does that, he has elected other than what is provided for in Order 3643. Where he makes that election at the case management stage, and the court has made an order appropriately.
Mr. Secretary, you realize that Order 36 Rule 4 is only regulating order of speeches.
My lord, I didn't quite.
Order 36 Rule 4.
Yes, that's the
it's
next.
only regulating the order of speeches. That's all that the rule is seeking to do. But Atra.
Yes, but my lord.
How can the law state that a party compel a party to give evidence by all means?
No, my lords, respectfully, if you say that the order of speeches
yes.
is all that.
Yes, order of speeches.
Yes, my lords,
yes.
That's a head note.
Yes.
And your lordship knows very well that the head note does not settle the interpretation of the provisions. I mean, Bernard Mona's case is a classic instance where the head note was shown to be completely different. And in fact, if we were only dealing with order of speeches, then my learned friend is completely out of court, because if that provision is only to do with order of speeches, then he cannot, on the basis of that, be asking your lordships to do or be telling the court what he told the court. If it's just order of speeches, then it will be interpreted as such. So it cannot be just order of speeches.
These proceedings are.
I'm sorry.
Of Order 36. These proceedings are tracked.
Yes, but Order 36(4), as his lordship pointed out, is order of speeches. That's what your lordship pointed out to me, and I agree. It says order of speeches. And I'm saying that the head note cannot limit the terms of that order, respectfully, because in fact, if your position were to be accepted, respectfully, then you should throw him out of court completely, because we are not yet at the point of order of speeches. We are not yet at that point. So if all that 36 Rule 4(3) is dealing with is order of speeches, then all he said is irrelevant, because we're not yet at order of speeches. But the reality of the matter is that that head note cannot limit the terms of Order 36 Rule 3. I believe that.
Mr. Chikasa, isn't compelling someone to testify a human rights question?
Also, my lords, I'm sorry. My lords, this is new territory. I mean, I have to think of it because frankly,
nobody can compel a party to testify.
My lords, frankly, I have to give considerable thought. In fact, yes, I have to give considerable thought to what you're saying. That you're not.
I mean, as I'm sitting here, I'm reviewing this whole thing.
Yes.
I mean, nobody can compel a party to testify.
My lord,
that's a very basic rule.
My lady, as I said, I mean, your ladyship has been part of a part of a ruling in this court which said the right to vote is part of the directive principles of state policy.
Chief Justice, please, may I have your attention?
Yes.
Please, none of us, at least those on the bench, none of us anticipated this step.
Exactly.
So please come, both of you come and address us on this point tomorrow. Then you will give a ruling on it and then proceed accordingly.
My lords, I was actually going to make a similar submission because it is my respectful submission that for an application of this nature under Order 19, it should be made in terms of a motion paper and a supporting affidavit so that we can respond appropriately. No. Because, my lord, that application that is being made...
Please, with all respect, please, there's nothing factual about this application. Yes. Let's take it. If he comes tomorrow to raise this legal issue, you have the opportunity to reply. So please, just prepare.
Very well.
And bear with us tomorrow.
Very well. Very well.
Yes. Please, we want to know your position because you have also filed a witness statement.
Yes. My lords, we do not intend to call any witness.
Okay, then you prepare.
And my lord, let me complete.
Order.
We do not intend to call any witness because in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
Please, we don't want lengthy answers. Please, what we want you to do is to prepare, come and address us on it tomorrow. Then we will give a reasoned ruling on it and proceed accordingly. Thank you very much. Please, you will rise for the day.